난 꿈을 꾸네 설레는 마음 가득.
Assalamualaikum and hi everyone. My name is Muhammad Ashraf Haikal bin Zainal Abidin. My metric number is 056813. I am from Gemas Negeri Sembilan. As for my academic background, I was studied in Mat Ahmadi Gemenceh, Negeri Sembilan during my secondary school. Then when I was 18, I was admitted into UNIZA and I managed to graduate in Diploma in Law. And for my current education, now I'm working hard to achieve my LLB, which is degree in law in University Sultan Zainal Abidin. My aspiration in studying law is my family itself. I want to serve my family as best as I can do. I can see bright future in this field, so I won't be hesitate to continue my journey. Wish me luck. So, the question is whether the MCO could cause breach of contract. Briefly, I would like to explain what is MCO and breach of contract. MCO or Movement Control Order is a cordon sanitaire implemented as a preventive measure by the federal government of Malaysia in response to the COVID-19 pandemic in this country. Due to the MCO, businesses except for those categorized as essential services have been restricted to carry on its activities until the end of the MCO. Generally, once a contract or agreement is signed by both parties, it is a legally binding contract. The parties are obligated to adhere to the terms and conditions of the contract and to perform their contractual responsibilities as set out in the agreement. However, the restrictions and limitations arising from the COVID-19 thereto have caused difficulties to many of the contracting parties who are struggling to meet their contractual obligations. Thus, Section 7 of COVID Act 2020 stated that if a party is unable to perform their contractual obligations pursuant to the Prevention and Control of Infectious Disease Act 1988, the innocent party will not be entitled to exercise their rights under the contract. In my opinion, there will be two answers in order to determine the breach of contract during MCO. This is because it will depend on the facts of the case and terms of the agreements which have been agreed by both parties. Moreover, the relief from non-performance will be found in the contract itself in the form of force majeure provisions or any provisions that carry the same effect to it. Force majeure can be defined as any circumstances beyond the control of the contract caused by terrorist acts, governmental or regulatory action, epidemics, and natural disaster. Likewise, the pandemic itself falls within this definition of a force majeure event. In short, a party who is able to claim relief for a force majeure event will be entitled either to terminate the contract with no liability on the non-performance or to suspend the time for performance, but this will depend on the language of the provision. Other than that, there are several important factors that must be highlighted in order to apply the force majeure clause. Firstly, the parties must determine whether does the COVID-19 outbreak or the MCO fall within the ambit of a force majeure clause. It is unlikely that the event of the outbreak and the MCO will be explicitly referred to in a force majeure clause. Some clauses contain catch-all provisions such as act of God or beyond the parties' reasonable control. Hence, it is highly dependent on the wording of the clause. Secondly, the parties must determine whether the non-performance was unforeseeable and beyond the control of the parties. In this current situation, the extent of the nationwide MCO is unforeseeable considering this measure was never before seen in the Malaysian history. Lastly, there must be certainty whether the performance has been hindered or impeded by the event. The defaulting party will have to establish the causal link of COVID-19 and its inability to perform. All government and private agencies necessary to facilitate the completion of SPA or Sale Purchase Agreement or performance of a contract are ordered to be closed. Due to that, it is impossible for the parties to timely perform under the contract due to the inability to deliver or receive the relevant documents under the contract from all the parties. Therefore, there are two further important information that need to be discussed under this context of MCO. Firstly, whether contractual obligations of parties can be suspended during the MCO period. For a contract that contain a force majeure clause, depending on the wording of the force majeure provision itself, the party who successfully relies on such clause is entitled to suspend the time for performance during the MCO period. This would mean all the compliance dates or completion dates stated in the contract therein are extended by the period of a valid suspension. In the event there is no such right available to the parties in the clause, the defaulting party will have to look to other provisions of the contract. Secondly, whether the contract can be terminated unilaterally in the absence of contractual performance. If the defaulting party successfully prove that the downstream consequences of COVID-19 falls within the scope of the force majeure clause, the defaulting party will not be liable for breach of contract. In such circumstances, a premature claim for breach of contract may render the defaulting party to bring a claim for damages for unlawful termination of the contract. In the absence of express provision in the contract, the court are typically unwilling to imply a force majeure clause into the contract. In such circumstances, the defaulting party may consider asserting his defense under the doctrine of frustration. The doctrine of frustration is found in Section 52, Clause 2 of Contract Act 1950, where it stated that the act will become unlawful or impossible after the contract is made. The contract shall then be deemed as void. In conclusion, while force majeure provisions can be helpful to the influenced party to disavow its obligation, it is anyway eccentric as in the viability of such proviso in exceptionally reality explicit and relies upon the terms and conditions of the agreement, administering law, and genuine conditions. Hence, it is fitting for the gatherings to assess the agreements completely to decide the alleviation accessible with regards to COVID-19 and its downstream impacts and outcomes. In preparation of my e-portfolio, I had to take the help and guidance of some respected persons who deserve my deepest gratitude. As the completion of this assignment gave me much pleasure, I would like to show my gratitude towards Professor Dr. Zohairah Arif binti Abdul Gadas, Dean of the Faculty of Law and International Relations, for giving me good guidelines for assignment throughout numerous consultations. I would also like to extend my gratitude to all those who have directly and indirectly guided me in writing and creating this e-portfolio. In addition, a thank you to Dr. Farhanin binti Abdullah Shuhaimi, who is also my lecturer for this contract law too. I also thank the University Sultan Zainal Abidin for consent to introduce me a new normal types of learning during this pandemic COVID-19 so that I can have a chance to own and write my personal e-portfolio in YouTube. That is all from me. Thank Allah and thank you all for your supports. Stay safe and stay at home. Thank you.